This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today it's time to speak about a fake claim with fake experts makes a claim fail, where an expert can prove that all claimed damages by the insured are wear and tear. The experts for the insurer defeats fake claim experts, fake construction experts who really don't have the ability to opine. The United States District Court was faced in John Hall versus State Farm Lloyd's, a July 28, 2022 decision of the Southern District of Texas, Houston Division. The court noted that it is not proper to try to shoehorn a distant explosion into a claim for property damage to an old, worn-out house whose damages had no relationship to an explosion. In fact, making the claim for pre-existing damages is, by common definition, fraudulent. John Hall alleged that his home was damaged by an explosion that occurred 1.8 miles away from his house. State Farm moved for summary judgment in his lawsuit by submitting reports from two engineers who separately inspected the property and concluded that the damage they observed was not caused by the explosion, but instead by normal wear and tear, minor material and installation deficiency, a lack of maintenance, as well as expansion and contraction of the building materials due to naturally occurring variations in temperature and humidity, something that happens in Houston a lot. Hall had a homeowner's insurance policy with State Farm. The policy insures for accidental direct physical loss to the property, but it does not cover losses caused by natural wear and tear, deterioration, or settling, cracking, shrinking, bulging, or expansion of foundations, walls, floors, roofs, or ceilings. On January 24, 2020, a propylene tank leak caused an explosion at Watson Grinding and Manufacturing in Houston, Texas. Hall's home, which was built in 1960 and which Hall purchased in 1983, is 1.8 miles from the explosion site. Hall did not hear or feel anything from the explosion, which occurred while he was asleep. He heard about the explosion later that day on the news. After learning of the explosion, Hall inspected the home but did not see any damage at the time. Hall began to suspect that he did in fact sustain damage to his home from the explosion only when the ceiling in his garage fell down 6 or 7 months later in July or August of 2020. After Hall removed fallen sheetrock from the garage floor, he inspected the ceiling and noticed that the joists were bowed. Hall saw no other damage on the inside or outside of his house. Hall retained counsel and submitted a claim in September of 2020 under the policy. In April of 2021, Hall filed a lawsuit against State Farm, even though it had not yet resolved Hall's claim. The delay was largely due to difficulties in getting the property inspection done. The complaint included seemingly irrelevant and false allegations, including that State Farm acted in bad faith in an action for property damage due to plumbing leaks, and that the insurer was found to have hired an investigating firm biased against finding liability. Hall's claim was not for plumbing leaks, and State Farm had not denied Hall's claim at that point. State Farm had inspected Hall's property only a few days before Hall filed his lawsuit. One reason for the delay was that the engineer State Farm hired to inspect Hall's property asked to be removed from the assignment because of concerns in regard to communications between Hall's attorney and the engineer and directives from Hall's attorney on how the inspection was going to be completed. That engineer later submitted an invoice for the amount of time he spent unsuccessfully attempting to coordinate the visits to Hall's property. In short, Hall's counsel appears to have been the significant reason for State Farm's delay in adjusting the claim. State Farm did retain a second engineer, Dan Rich from Rich Engineering, who was able to inspect the property in March of 2021, but not without difficulty. Hall's counsel refused to allow Rich to speak with Hall regarding the history of the residence or the damage that was being attributed to the explosion. At the time of the inspection, Rich Engineering was not informed of what damage Mr. Hall was specifically attributing to the explosion. After the inspection, Rich Engineering emailed Hall's counsel a list of questions about the property, but neither Hall nor his counsel responded. Based on this inspection, Rich Engineering concluded that the residence was not damaged by the explosion. His report stated that the foundation was not damaged by the explosion. Cracks in the drywall were consistent with normal wear and tear, minor material and installation deficiencies, a lack of maintenance, as well as expansion and contraction of the building materials due to naturally occurring variation in temperature and humidity. The roof was not damaged. Cracks in the attic framing were aged, indicating that the damage predated the explosion. The brick veneer cracks had an aged appearance, which indicated they predated the explosion, and Rich Engineering did not observe any broken window panes during its site visit. As a result of Rich Engineering's report, State Farm informed Hall's counsel in May of 2021 that it was denying Hall's claim. The denial letter stated that State Farm's investigation revealed the residence was not damaged by the explosion. State Farm also hired a structural forensic investigator to inspect the property. BSC Forensic Services, LLC, to document conditions consistent with the effects of an explosion that occurred on January 24, 2020 at the Watson grinding facility, if any. The BSC report noted that BSC's inspection revealed no conditions at the subject property that could be attributed to energy waves associated with the reported explosion, and noted that the surrounding properties of similar construction also exhibit no such evidence. The report concluded that the collapsed ceiling in the garage was attributable to long-term sagged condition of the ceiling joists associated with improper lumber and excessive loading from the roof beam supports in the attic space above, and that the condition was not caused or exacerbated by the reported explosion. Hall, trying to support his claim, hired two experts to testify, whose testimony State Farm objected to. Hall's expert responded with a report from an engineer who did not visit the property, did not review State Farm experts' reports, and did not state any basis for opining that the home, quote, seemed, close quote, to be damaged by the explosion. Hall also submitted a report from a meteorologist whose speculations as to the root cause of the alleged damage are both beyond his expertise and unhelpful. Rule 702 of Federal Rules charges trial courts to act as gatekeepers, making a preliminary assessment of whether the reasoning or methodology underlying the testimony is scientifically valid, and of whether the reasoning or methodology properly can be applied to the facts in issue. Expert testimony must be both relevant and reliable to be admissible, and the court found that the two experts retained by Hall were neither expert nor reliable. State Farm's motion for summary judgment was granted because the dispute was whether the damage to Hall's home was caused by an explosion months earlier and 1.8 miles away. State Farm presented ample evidence that the residence was not damaged by the explosion. Hall's evidence, construed generously, supports only the conclusion that Hall's home had several structural issues, as demonstrated by the photographs and the reports of the State Farm experts that an explosion 1.8 miles away occurred in January of 2020, and 6 months after the explosion, parts of the garage ceiling fell, and some cracks were found. Hall presented no evidence that the explosion did, in fact, damage his home. As a matter of law, State Farm did not breach the policy by denying Hall's claim for coverage. The breach of contract claim was therefore dismissed. Hall did not point to or present admissible evidence showing that State Farm violated the Texas Insurance Code, engaged in deceptive trade practices, breached the duty of good faith and fair dealing, conspired to commit illegal acts, or committed fraud, and those claims were also dismissed. In my opinion, the decision was obvious. State Farm presented evidence and Hall presented speculation while working hard to set up a bad faith case against State Farm by refusing to allow their experts to get into the property to check. By dismissing the suit, the court did what it was required to do. It should, however, in my opinion, also have reported Hall to the U.S. Attorney for attempting to defraud State Farm with a spurious claim. This video was adapted from my blog posting at zalma.com/blog, where you can subscribe for free to obtain regular blog postings by email. Thank you for your attention.